Is the H-1B dream officially dead, or has the game simply mutated into something much more dangerous for the unprepared applicant? For years, the H-1B lottery has been the ultimate prize for international students and tech workers, but the Department of Homeland Security and USCIS have just dropped a series of updates that signal a complete game over for the system as we knew it. We are witnessing the death of the old registration-centric model that allowed consultancies to game the system and the birth of a beneficiary-centric process designed to level the playing field. But while the headlines are celebrating the end of fraud, there is a terrifying new reality brewing beneath the surface. A silent killer in the form of skyrocketing denial rates and aggressive retroactive audits is waiting to ambush even the most qualified candidates. If you think getting selected in the lottery is the hard part, you are operating on outdated logic, because the real danger now lies in a specific trap within the new application review process that is catching thousands of honest applicants off guard. Let's dismantle the biggest change first, which is the shift to the beneficiary-centric selection process. In the past, the H-1B lottery was a volume game where the more employers you could get to register you, the higher your chances of winning. This created a toxic environment where shady consultancies would flood the system with multiple fake registrations for the same person, turning the lottery into a pay-to-play scheme. That era is officially over. Under the new rules, your passport number is your unique identifier. It does not matter if you have one job offer or 50 job offers, you are entered into the lottery exactly once. If you are selected, all your potential employers are notified, and you hold the power to choose which offer to accept. This effectively kills the advantage of the body shops overnight, and theoretically boosts the chances for legitimate applicants with single job offers. However, this new system has a double edge. Because the artificial inflation of registration numbers will collapse, the USCIS now has the bandwidth to scrutinize the remaining applications with a level of intensity we have never seen before. This brings us to the second critical update regarding fraud prevention and the new collusive relationship investigations. You might assume that because you are honest, you are safe, but that is a dangerous misconception. USCIS is utilizing advanced data analytics to map out networks of companies that share office space as executives or filing pattern. If your legitimate employer uses a legal firm or a shared workspace that is flagged in their system, your application could be pulled for a complex review. We are seeing a surge in notices of intent to revoke being issued for petitions that were approved years ago. This means the government is looking backward. If they find that a company you worked for in the past was part of a fraud ring, they might question your current status today. The new rule explicitly allows USCIS to deny or revoke a petition if any part of the registration contained a false attestation. You are no longer just an employee, you are now guilty by association if your employer's history isn't spotless. But the most immediate threat to your American dream is the rising denial rate based on the specialty occupation interpretation. This is the trap I mentioned earlier. Getting selected in the lottery is now only the beginning of the war. USCIS adjudicators have shifted their strategy to aggressively challenge whether a job actually requires a specific bachelor's degree. In the past, a software engineer role was easily approved. Now, if your degree is in electrical engineering but your job is in Java development, they are issuing massive requests for evidence, arguing that your degree is too generic for the role. They're stating that a general engineering background does not prepare you for a specific software job. This disconnect is devastating entry-level applicants, particularly those on F1 visas. If your employer cannot prove a direct and complex link between every single course on your transcript and your daily job duties, the petition will be denied regardless of your lottery selection. Furthermore, we have to talk about the right to control crackdown, which is decimating third-party placement petitions. If you work for a consultancy that places you at a client site, USCIS wants to know who your actual boss is. They are demanding contract statements of work and purchase orders that explicitly name you. If the contract between your vendor and the end client is vague or expired, your case is dead. They will argue that the petitioner does not have the right to control your employment, effectively labeling the job offer as illegitimate. This is combined with increased scrutiny on level 1 wages, where the government argues that if a job is complex enough to be an H-1B specialty occupation, it cannot logically be paid at an entry-level wage. This catch-22 is trapping thousands of applicants who are trying to enter the workforce during a time of budget cuts. So, is the dream dead? No, but the era of the easy H-1B is buried. The winners in this new beneficiary-centric era will not be the ones who just get lucky. The winners will be the ones who treat their application as a legal battle from day one. You must vet your employer's filing history just as hard as they vet your resume. You must ensure your job description is a customized legal argument, not a copy-paste from LinkedIn. The lottery has changed from a game of chance to a gauntlet of compliance. If you adapt to this high-scrutiny reality, you can still secure your future, but you can no longer afford to be a passive participant in your own immigration journey.